talk about how CCK handles a case that kind of comes in the door. What are the steps that we take when we initially start working with a veteran? We're not going to talk about specific cases. This is more of a hypothetical discussion that Claire and I want to have. But this is a reflection of the steps that we take, the work that we do, and the process that a veteran needs to go through, oftentimes to get the maximum benefit that they're seeking when they come to us for help with their benefits claim, a denial. So Claire, start us off and kind of set the scene. What are the things that we do when we first become a representative of record on behalf of a veteran, maybe let's say that has a denied claim when they come to us?
Yeah, so when we begin representation, we typically want to take an inventory of the entire case. So we'll map out all of the decisions, all of the medical records, and we'll kind of form a strategic plan for how we want to approach all of those issues. So we might see that VA has denied based on a deficient compensation and pension exam. And in response, we might argue for a new exam. We might obtain our own medical evidence to counter the VA examiner's findings. We may develop our own lay evidence from our client, to talk about missing aspects. Because typically when something gets denied, not always, but often there's some piece missing. So maybe there's a gap in treatment. Maybe there's a diagnosis that's unclear. Maybe there was an event in service that isn't documented. And so we want to help fill those gaps to really round out the claim and make sure that it's completely developed. And sometimes we might also ask VA to assist our veteran by getting another exam, requesting records. Those could be service records. Those could be post-service treatment records. And another thing that we assess for are kind of secondary or ancillary issues to the main issues that we see. So maybe a veteran comes to us seeking an increased rating for an orthopedic condition, and we might find that they have a really common neurological residual of that impairment. So a back disability can affect your nerves, which can cause numbness in your hands, your feet. And so we might look into those secondary conditions to help maximize a veteran's benefits. There also might be secondary conditions that are not necessarily complications, but are conditions that are aggravated or caused by the primary disability. A big one that we see a lot is sleep apnea. So a veteran with post-traumatic stress disorder or other psychiatric conditions, those can cause sleep disturbances that can really worsen the severity of a sleep-disordered breathing condition like sleep apnea. And then a big thing that we help with is looking for other higher benefits like TDIU, special monthly compensation, other benefits that might not necessarily fit into the box of an increased scheduler rating, but still would nonetheless increase a veteran's compensation.
Great. That's a great overview of the substantive work that we're typically doing that we are doing on every case. We're also typically kind of working behind the scenes to work on the process of it all. So everyone out there who's pursued a claim or appeal for benefits knows that delay is a super common component of that process. So something that we do at CCK is active monitoring of our clients' online files. Because we are accredited, we have access to VA's automated claims records electronically. That allows us not just to obtain our clients' electronic files, but also to monitor the status of a pending claim or appeal. So in addition to doing all of the strategic development evidentiary work that Claire described, filing appeals, getting medical experts when needed, we're also doing things like emailing the regional offices if we notice that a claim at the RO is stalled, or sending status letters to document in the record that a client has been waiting more than the average time for a decision on something. If we notice that VA doesn't get the appeal that we send, we successfully submit it, but they haven't set up a task essentially for their adjudicators to address it, we check on that stuff. We make sure that everything's moving the way it's supposed to. And if it's not, we do outreach to VA to ensure that our clients are getting timely decisions. It's not something that we can control, and there's a ton of room for improvement. Again, people who are in the process know that delay is just part of the deal. But we do try to take steps to mitigate that delay, to keep VA on their toes, so that we can obtain the results that our clients are looking for us to obtain for them, that we're working with them on. We assess for things like eligibility for advanced treatment. There are some veterans, because of POW status or Medal of Honor status or age or hardship, can get expeditious treatment at the regional office or advancement at the board. So we always look for those avenues too, to be able to kind of combat the standard VA delays that permeate the process. And then after we get negative decisions, and I do say decisions plural intentionally, we're filing a lot of appeals. This is an area where Claire is one of our experts, frankly, on appeal writing, drafting, and strategy. So talk to us a little bit about what that process entails.
Yeah, so I think part of what delays the process is not just that we wait on decisions, but it's that when we do get decisions, they're not the decisions that we want. So, we can pressure the regional office to expedite the case, but then the resultant decision that we get might be just an inadequate statement of reasons and bases. It might miss important evidence, or it could be a partial or piecemeal grant of what we're looking for. This is a really common thing that we deal with, particularly with something like the PACT Act from August of 2022. VA passed this liberalizing law to make it a lot easier for veterans with toxic exposures to receive benefits. But what they overlook often is that these claims were pending before the PACT Act was passed into law. So they may grant a benefit from the date of the PACT Act and overlook that the claim was pending years before that law was passed. And so sometimes we'll get a partial grant from August 10th, 2022, and we'll have to push to get the effective date all the way back to the date of the claim. We might get a partial grant of TDIU from the date we file our appeal, which is not correct. We want to push it back to the date of claim or the date entitlement arose. And so we can do this in several ways. We have a lot of appeal options at the regional office and at the board. One option that we've had success with and that we're excited about is the claim accuracy request. This is an expedited, shortened 30-day turnaround. It's very quick, but accredited agents can use this claim accuracy request option to seek an expedited review of an obvious error. So an obvious error that we see often is that a veteran will file a claim, he or she will get a decision, we will file an appeal, and then VA will only grant from the date of our appeal. And so we file a claim accuracy request to push it all the way back to the date of the claim. And that's a way for us to expedite the process of getting the benefit that we know that our client is entitled to. Sometimes we have to continue appealing all the way to the Board of Veterans Appeals, and even then, we do not get the decision that we're looking for. So something that I think CCK offers that not every advocate can do is we have a team of court attorneys who exclusively specialize in appealing cases to the Court of Appeals for veterans claims. And so if we receive an unfavorable result at the board, we can keep fighting at court. We can continue to push the issue there. And the court can then vacate a board's decision and remand the issue back for another bite at the apple. So, sometimes we have to take a case all the way to the board, all the way to court, sometimes multiple times to get the outcome that we want. So that is part of the delay as well, is even when we're getting decisions, the overall process is prolonged by having to continuously appeal.
Exactly. And it's incredibly frustrating for our clients who have to deal with the process of getting denial after denial at the regional office, at the board. And like Claire mentioned, I can remember from the days when I was doing work at the court as well, I would see sometimes the same case a couple times, the same issue, making the same kind of arguments even at court, because that's a product of the board denying and getting it wrong multiple times on the same issue. And that's already at the board, never mind what's already happened at the regional office. So we do our best to get speedy, benefits for our clients, of course, that's our job. And we also are needing to be very persistent. Sometimes we're appealing the same thing 7, 8, 9, 10 times. It's just part of it sometimes. And like Claire mentioned, sometimes we find ourselves in court multiple times on the same issue, and sometimes we even need to push the issue beyond the CAVC. So some very exceptional examples, but things that could happen from a case that just starts as an increased rating matter or a service connection matter. Sometimes at the court, the issue presented is one of particular legal importance or novelty. Sometimes in those cases, the U.S. Court of Appeals for Veterans Claims will call the case to panel, meaning that instead of dispensing with the case via a single judge decision, which is the most common outcome we see at court, other than agreed upon remands from the Office of General Counsel if we're able to negotiate that. Sometimes the court wants to make a precedential decision. So they'll call a case to panel for oral argument and or call a case to panel for review and a precedential written decision on the matter because it's a particularly novel legal issue. And so that can cause more pleadings, effort, advocacy on our part. Thankfully, our team is very skilled in doing this. CCK has obtained over 100 precedent-setting cases over the years. This is just something that is rare but does need to happen occasionally. If we receive an unfavorable decision from the U.S. Court of Appeals for Veterans Claims, in a very, very, very small percentage of those instances, we have the opportunity to appeal to the federal circuit. It's not something that is on the table very often, but we have a team that's able to do it, and we have done it, and we've won there, we've lost there, all of the above. And so, yeah, this was, I think, meant to give an idea of all of the things that can come up in a case, all of the things that our team is thinking about in various respects, evidentiary development, appeal strategy, mitigating delay strategy on top of all of that, being at the ready for pushing a case to the board, to the court, and beyond. A lot of these things are happening. They can be happening at multiple times. If a veteran's pursuing multiple issues, you might have one thing at court and one thing at the regional office. It's a very, very complex system, but hopefully this discussion gave a sense of our readiness to approach it and also the path that a veteran's case might take. Hard to tell when they're first filing their first claim that it's going to be like that, but this is a tricky process to navigate for a reason, and this is the kind of thing that can be the outcome or the path that a lot of our efforts will take.